Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the Free Legal Advice Show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I'm able to cover a vast, diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please do get in touch. Two ways to get in touch. You can ring us live here in the studios on the landline number which appears at the bottom of the screen. Alternatively, you can send us a message, text message, WhatsApp message on that mobile number which also appears at the bottom of the screen. So two ways to get in touch. To speak to us live, the landline number is there, and for messages, text, WhatsApp messages, you've got the mobile number there as well at the bottom of the screen. Now on the show we get numerous questions on immigration law, which is fantastic, with callers calling in and messages coming through on that mobile number. Fantastic. But I can advise you on other English legal matters as well. Now if it transpires that your matter is complex or I need to look at documents before I can advise you properly, then I will ask you to leave your number with the control room, or you can get my number from the control room and then you can speak to me off air as well for complex matters, a service that we provide completely free of charge as part of the Free Legal Advice Show. So we've had a number of questions coming in already, even before we came on the show today, live here today. First question is regarding an immigration law question, and it looks like it's a question relating to spouse application. So I'm going to have a look at the questions with you, our viewers, just now. I haven't looked at the questions yet, and let's then have a look at what the best advice for our brother is who sent this question in. A question from brother Muhammad Huzaifa, and he says, I have recently got married in Bangladesh. I want to bring my wife here in the United Kingdom. What do I need to do in order to bring here to the United Kingdom? Please let me know. Now, quite a wide subject. There's quite a few things that you need to do in order to sponsor your wife to come to the United Kingdom. A number of different aspects. We'll break it all down as we go along, but there's issues relating to the validity of your marriage, your finances, your accommodation, and your relationship. So quite a few different areas that we need to look at. What I tend to say to clients is that, first of all, focus on the documents that your wife needs to get you from Bangladesh. And then we can look at the documents that you need from the United Kingdom. So I normally, with clients, break it down in those two different parts. Now, this is quite a detailed question that I need to take you through. We have somebody who's been waiting for a while. I do apologize to brother Muhammad who texted that question in. Let me take the next call, but I will come back to you on this today live and I will give you a detailed answer. But let me go to the caller who's been waiting for a while. Hello, assalamu alaikum.
Walaikum salam. Brother, how are you?
Alhamdulillah, good. How are you, brother? You okay?
All right. I just go with one of your question. Basically, I made my application, for my wife, basically, and it's been pending with the Home Office about 10 months now.
Okay.
And I made basically pre-action protocol on 23rd of May last month, right? And they sent a response to me within 2 weeks on 6th of June and tell me, sorry, we're unable to obviously provide you any information, right? So we're looking for further than 14 days from the 6th of June to 20th of June.
I understand.
When the 20th of June passes, well, yesterday, they emailed me again yesterday, and I'm looking for further extension for 14 days.
Yeah.
So my question is, right, they're not meant to be basically like give any answer within 14 days. If no, obviously they never give me the answer in the first 14 days, and then they extended it. And they never give me an answer in the next 14 days either. Now they extended basically again. So I just wonder, is that what the procedure basically is for a pre-action protocol? I mean, they keep extending it. They basically did extend it 3 times already.
I understand completely where you're coming from. And this is what we are experiencing in practice as well. But brother, let me just go back one step. The application that you submitted, which is outstanding, Is it a 10-year route application, an FLRFP application?
It's entry clearance application from abroad.
Or an entry clearance application from abroad that's taken 10 months?
10 months, yes.
That is highly unusual for it to take 10 months.
Right, so the reason was, I think I have spoken to you last time as well.
Okay.
I'm a single parent, right? So I got...
I remember this. I remember this.
And I do not have indefinite leave
to remain, so but because you're looking after your daughter, there are exceptional circumstances in your
exceptional circumstances, yes.
I 100% remember, because we've had a couple of discussions. For me, from a legal perspective, an interesting query. From your perspective, it's very personal. That's something that needs to be sorted out. Look, in the end, what happens is this. The pre-action protocol letter, it does normally get you a response. But let's say they keep on delaying it. They say, give us 14 days. And then they say, give us another 14 days. The problem is legally, they're not compelled to give an answer. So when they keep on delaying dealing with it, then your option then is to, at that stage, issue proceedings in court for judicial review. And the judicial review case would be that they haven't dealt with your case. So the fact that a decision isn't issued, it's the same as a wrong decision being issued, an unreasonable decision being issued. So it's something within judicially reviewable in the same way as incorrect decisions are judicially reviewable. My only concern, brother, is that when you actually go to court, 10 months isn't considered to be a significant delay. That's my only concern. The decisions on delay which are successful are normally delays of years as opposed to months. This is my concern. So I completely agree with the process that you're going through, pre-action protocol. You could even go to your MP and you can even submit.
I have tried, to be honest, MP about 4.5 months ago. Basically, I met my MP the first time. And I still got, MP still never had anything from the Home Office within 4.5 months. So I really cannot make in a situation where I think, I'm seeking help, right, but I can't get any help, right? I mean, I just...
What about a complaint? Have you tried the complaints process?
I tried a complaint. Well, I sent them email online, and they basically back to me within, I think, 28 days, and they tell me it's just because I'm a sponsor, right? So they're looking for something written by my wife, right, to clarify. I mean, I could act on her behalf. And then I could pass on to them, and then they say that if you can't do that, then you go to tell your wife so she could make a complaint on her own behalf.
So could you pursue that as well? Then could you not just get a authority letter from your wife, basically saying? Right,
I didn't get it because I was just about to making a pre-action protocol. So I could hear from them as soon as possible.
Sometimes what I've noticed is the complaint. When you do submit a complaint, they do look at it. The only problem with the complaint is sometimes they come back and say, we uphold your complaint, we agree that it's unacceptable, this level of delay. But then they say, but we can't guarantee when the decision is going to be issued in the same breath. This is the slight problem. But in the end, the challenge can only be pre-action protocol, complaint through the MP, or complaint to the Home Office yourself. There isn't anything. I think what the MP can do is refer the matter specifically to the Member of Parliament responsible for this department. My only concern is, look, the pre-action protocol, the next step is judicial review, but I don't think the case is strong enough for judicial review. The delay is...
Do you think at some point is eventually going to, according to pre-action protocol, they're going to give me an answer at some point, because they keep extending the 3 times already, which is obviously a month now. It's over a month now.
I think they will give you a response, but it could be another couple of months before they give you a response.
So they're going to, obviously, when they basically given, sorry, I'm not to take phone calls too long, right? But see, when they keep extending it, obviously, as I say, they sent an email to me yesterday and they were looking for another 14 days, which is 4th of July.
Yep.
Now they're going to send something out to me in the 4th of July again to, either they're going to give me a decision or they're going to extend it another 14 days.
I suspect they may continue to extend it if they can't get an answer. But you should continue to pursue that. My personal view is pursue all avenues. If I was in your situation, I wouldn't look at going to court yet. Okay, pursue the pre-action protocol, pursue the matter with the MP, and submit a complaint. So you could look at all three avenues. The only problem with the judicial review is if they turn around and say, we're looking at it, there hasn't been any undue delay, the court may agree with their position. You might have to pay their costs. That's the only problem. If the court agrees that there hasn't been a significant delay, you might have to pay their costs for dealing with your judicial review application. So maybe avoid or hold off with the judicial review. Push the pre-action protocol, complain through your MP, complain on behalf of your wife. I think there's no harm in pushing at all fronts.
Right. So what about if I just try to do something as a complaint, if I ask my wife, she could complain directly herself?
Oh, she could, or you could get an authority letter signed by your wife. Your wife confirms that I give my husband.
I know, but I should definitely get any answer back from them like that.
The complaint does, surprisingly, the complaint does result in a response. Might not be straight away, it might take a month, 2 months, but the complaint does normally get you a response. But I would pursue all avenues, pre-action protocol letter, MP, and a complaint. Maybe the problem is it's not strong enough for judicial review at this stage. But in the end, you could say, you know what, I don't care if I have to pay £1,000 in costs. I want to go down the judicial review route. You could take that view. But from a legal perspective, at the moment, there isn't enough delay to successfully be successful in a judicial review.
Yeah, that's when. Sorry, just one more question just before you go.
No problem. Brother, we are taking a short break, brother, in the next few seconds. If you don't mind holding, I will come back to you straight after the break. I'll see you in a few minutes. Assalamu alaikum. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to us live on air, please ring on the landline number which appears at the bottom of the screen. And the mobile number's there to send us a message with your query. And fantastic, we've been receiving loads of queries and I will go through them today live during this show. We had a caller calling regarding a spouse application where the decision's been delayed. I did have to cut the caller short as we were going for our break. Just going to check whether the caller is still there or not. Hello, assalamu alaikum.
Yes, Islam, sir.
Brother,
so
thank you.
The second question, sorry, so the second question of if I go for judicial review, is that going to be a lengthy process? Like, for example, I just want to know what the time frame is.
Okay. So judicial review has a number of processes, a number of stages. You will submit your paperwork to the court and then serve your paperwork onto the Home Office. The Home Office then has, from off the top of my head, about 28 days or something to respond to that paperwork. So they file in response to your claim an acknowledgement of service with their grounds within about a month or so. Then the matter goes to the judge for the judge to look at the papers. Now, how long does it take for the judge to look at the papers? It just depends how busy the upper tribunal is. Off the top of my head, I would say there are less judicial review claims being filed at the moment. So I would say the judge would take around maybe 3 months to look at the papers. So your claim goes in, Home Office within about a month or so files a response. I can't remember the exact time limits. Papers go to the judge to make a determination on the papers. Let's say the judge takes about 3 months. So you sort of know where you are initially with the response from the Home Office. They might well turn around and say, you know what, we don't agree that there's been a delay, but they might come back to you and say, we don't think we've done anything wrong, but here, you know what, you're going to get your decision anyway, so withdraw your a claim. Or your judicial review may prompt them to make a decision. They'll come back and say, look, we don't agree we've done anything wrong, but in any event, you've now got your decision, so why don't you withdraw your claim? So what I tend to do is use the judicial review to prompt them to do something. So within a month, they will do a response, so they will have to look at your file to do that. And then after that, at least you've got a second bite at the cherry, because it goes to a judge. The judge will, on the papers, say yes or no in terms of whether permission should be granted or not. So all you're doing is you're prompting them to do something. In the same way, the pre-action protocol letter, the MP approach, and the complaint does.
But the thing is, you know what my concern is, I know that they're busy obviously doing it due to COVID and obviously due to Ukraine war, but they meant to be taken 3 to 6 months. If the case was a complex, they meant to let someone, obviously the person know if your case is complex, will be taking more extra time, obviously, which is they took already 10 months, like, you know what I mean? So it's no basically telling me anything, right? So I'm just wondering about.
It's not that complex, is it? I mean, it's you've explained it to me before, and I exactly know what the issues are. So it's not, somebody senior just needs to look at it. Now, I accept a normal, the first level caseworker may not be able to make a decision on that. It needs a more senior caseworker to look at it. But a senior caseworker should be able to look at it and make a decision. It doesn't need 10 months for a decision to be made. So I don't think the complexity is such that it warrants a delay of 10 months because they haven't come back to you. They've not asked for anything. They've not asked for clarification. They simply just haven't got a senior enough person to deal with it. So it's not, I don't think it's more complexity. It's just the way they operate at the moment. Maybe short-staffed.
Right. No worries. Thank you very much. Right. Thank you very much.
No problem.
Thanks a lot.
Thank you very much for your call and best of luck with that.
Right. Thanks. Bye.
So just before we took that call, we were looking at the question from Brother Muhammad Huzaifa regarding bringing his wife over from Bangladesh to the United Kingdom and what needs to be done. Now, what I tend to do is advise clients that, look at what your partner who's abroad needs to get together. Normally, it's a copy of their passport, English certificate, A1 life skills, TB certificate, and a copy of the marriage certificate. So we're looking at 4 documents normally that we need to get together from abroad. Your partner's passport, English certificate, TB certificate, and the marriage certificate from abroad. So that's the documents that you get together from abroad. Let's look at what you need to get together. You'd put your passport in to show your nationality and the fact that you've travelled abroad to meet your wife and get married. Entry and exit stamps. Straightforward. Finances is then the main issue. So when parties are getting married for the first time, and it's similar age, etc., there's no nothing unusual. Normally what it boils down to is how the financial requirement is going to be met. That's where the key issue is. Now, the difficulty is that finances can be met in various different ways. But let me give you an example. If you are employed for more than 6 months, all you need to submit is employer's letter, 6 months wage slips, 6 months bank statements. And that needs to meet the £18,600 requirement. Now, if your income is more complex, self-employed, rental income, etc., there are different rules and you need to come back to me for that. So that's one aspect. Other aspect is accommodation. That's reasonably straightforward. Where's your wife going to live? Is there enough space? And then proving your relationship, which is normally done by photographs. But if you've got something more specific that you're concerned about, please do come back to me. But thank you very much for that message. We've got a caller who's been waiting for a while. Let's go to our next caller. Hello, assalamu alaikum.
Alaikum salam.
Yeah, brother.
Yeah, good evening. I wanted to ask a question in regards to citizenship.
Sure.
Yeah, I had indefinite leave to remain with my partner,
Okay.
but I got it through asylum.
I understand.
So it passed 1 year now.
Okay.
I wanted to apply for citizenship, but I have 4 kids. So it will cost us almost about £7,000.
Understand? Yeah.
But my question is whether me and my wife can apply after a year or two. We apply for the kids. Will that be possible, or it can't be possible?
No, it is possible. Absolutely possible. If you apply now and get your citizenship done, absolutely the children can apply later. It doesn't have to be done as a group application at all. So you can stagger it. You could do yours now, you could do your wife's later, and then you could do your children's later. Where there would be a problem is if you try to do the children's first, that might be an issue because one of the parents does normally need to have British nationality. So one of the parents would normally have to go first, or it be done together with the children. But in answer to your question, there's no problem staggering the applications as long as one of the parents goes first. Now, the other issue, brother, is this. For the children, now, I don't know what your financial circumstances are, but if you don't have enough income or savings, you might be able to get a fee waiver for the children's nationality application. I mean, I don't know what your circumstances are like, but that may be a possibility. I don't know whether you've come across that or not.
Yeah, the fee waiver, yeah. I heard it from you guys. Yeah, I heard it from you. I heard about the fee waiver, yeah.
All right.
Fee waiver, yeah.
Okay.
I heard about it, yeah.
I mean, it's just come in, I think, in the last couple of days. So,
yeah.
But the problem is with the fee waiver, they will assess your income and wife's income as well. They'll look at your expenses, wife's expenses, and your savings. So they'll do a full assessment. So I don't know whether you would qualify or not. But that's certainly something you could look at. But in answer to your question, absolutely no problem. You can go first, wife can go second if she wants, or do it later, and then you can do the children's later as well. Absolutely no problem.
Okay, that's fine. So if I wanted to have a consultation with you guys, is there any number that I can ring to book a consultation? So
to be honest, if you want to speak to me on the phone off air, I've got no problems. And I said before, I've got no problems giving you advice as part of the show. You can take my number from the control room, or you can Google my name. My details will come up on Google. But the control room will give you my number. I have no problems.
Okay, I will take it from the control room.
Yeah, I've got no problem speaking to you off air about it.
Okay, thank you
No
very much. Thank you.
Okay, brilliant. Thank you very much.
Bye.
Thank you.
Bye.
Thank you. Thank you very much. Just for the benefit of our viewers, in terms of children's nationality applications, it is now, or registration as it's called, it is now possible to apply for a fee waiver if you can't afford the fees for the children's nationality applications. Now, the fees are around just over £1,000. And certainly, like our previous caller, if there are a number of children in the family, then it is quite a hefty sum to pay. With 4 children, we're looking at roughly 4,400 or something of that magnitude. So it's a lot of money to put together. Now, if your financial circumstances are such that you can qualify for a fee waiver, then I would certainly advise you to try that option. Now, the problem is this is quite new, the fee waivers for children's nationality applications. That's quite new. And as time goes by, we'll get to see what kind of approach the Home Office is taking. Are they going to be very strict? Are they going to be flexible? What are they going to be looking out for? So one is them saying that, yes, there is a policy there that if you can't afford to pay for the fees for the nationality application for children, there is this process. You can apply for a fee waiver, but that's the policy, fine. But we do need to look at what actually happens in practice. And fee waivers, we have had those for a while for immigration applications. So, for example, human rights applications, we've had that for a while. And certainly when we had the pandemic, a lot of people lost their jobs, couldn't afford to extend their visas. And the Home Office was quite lenient in those days in terms of granting fee waivers. As we went on, I've noticed in the last few months that they are stricter, but they do grant it. So in the same way as we've learned how the fee waiver process works, what the approach of the Home Office is with fee waivers, no doubt over time we'll learn how the fee waivers are applied or granted in practice when it comes to children's nationality applications. So there is a process there. You've got nothing to lose. If you can't afford to pay for the nationality applications for your children, try the fee waiver route first. As I say, there's nothing to lose at all. It may delay the process by a couple of months. Roughly, that's how long it takes for them to make a decision. But absolutely possible to make that fee waiver application. Okay, hope that answers that question. Now, we have had a number of questions coming in on WhatsApp. I do intend to go through them, but we are taking a short break. And as soon as we come back, I'll try and address some of those questions that have been sent in. See you in a bit. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, as always, a popular way to get in touch is to send us a message on the mobile number which is also there at the bottom of the screen. So live calls here in the studio directly with me to have a quick conversation, please do ring on that landline number. Now, as I said just before the break, we've had a number of questions coming in on that WhatsApp number we have there. So let's look at some of those questions. Now, next question looks like a family law question, quite detailed. Let me read the question out and let's see what the solution is. And the message is as follows. Assalamu alaikum. My question's about family law, which is as follows. I'm a single parent with an 8-year-old daughter who lives with me. I have full residency order, but she sees her mum once a week due to the court order. My question is, if I need to go abroad, do I still need to get a court order to remove my child from the UK for holidays? What is the legal age for my daughter when she could come abroad with me without requiring consent from the court? Secondly, regarding contact when she is 16, can she decide herself whether she wants to see her mother or not? How long will the court order be in force for? Now, on that latter point, normally court orders are made for children up to the age of 16. Now, in exceptional circumstances, the court can extend that to children who are 18. But normally when it comes to residency contact, it's really up to the age of 16, although the court has power upon an application by either party to extend that to 18. I think the reason, and this ties in with your question about when can she decide, etc. The reality is when children get to a certain age, let's say 15, 16, the children decide for themselves as to whether they want to see the other parent or not. Now, and I'm not advocating this at all, if you face a situation where, despite the court order, a child simply doesn't want to see the other parent and expresses very strong feelings, and the other parent then goes to court and says, look, there is a court order in place, my daughter has to see me once a week. And if that's resisted by the child, the court then has to assess whether a child who expresses very strong feelings can still be made to have contact with the other parent or not. It's a difficult scenario for courts to grapple with because it's easier when children are younger, 8, 9, 10. But when children are much older, realistically, practically, can they be forced to have contact with either parent? Children decide really for themselves. And I think there is some difficulty that you could potentially have a court order in place saying the contact's going to take place on a Saturday every week. Child refuses to go. What do you do? How do you compel? You can't really compel that child who's now about to turn 16. So on the one hand, the orders normally stay in place up until the age of 16, but there is a particular problem as kids get older where there is resistance to contact from the child's side, and the court then has to get involved. In these situations, normally these things are best resolved by agreement by the parents and without things getting too messy for the children. And I think what I tend to find, leaving the court aspect to one side, as the child gets older, if the child wants more contact with the other parent, and in the same way, the other parent would find it difficult to control the child and the level of contact the child has with the other parent as well. So as the kids get older, I appreciate there are court orders we're talking about here, but as the kids get older, they do start deciding for themselves, certainly when they're around the age of 15, 16, as to the level of contact they are prepared to have with the other child. But in answer to your question, normally the court order would stay in place up until the age of 16. Now, the other question that you've asked is about the child leaving the country. Normally, the court order would deal with that, whether permission needs to be sought by the other parent or not, or whether... now, my understanding is, and I'm not a family lawyer, that if there's nothing that prevents the child from being taken on a holiday, then you'd be okay to do that for a short holiday. However, if the court order specifies what should happen when one parent wants to take the child to a holiday, you would have to follow what's set out in the order. But in the absence of a specific order relating to taking the child out of the jurisdiction, you would be able to take the child out for a short holiday. So hopefully that result, and I do, just looking at the question, appreciate that your daughter is quite young, 8 years old, and obviously not at an age where the child can start deciding for the child's self as to what should be done. So this is an age where there will be a court order obviously in place, and it would really have to be complied with. The order would have been made after Kafkas has interviewed you, the other parent, and obviously the child at a younger age. In terms of the child's wishes, less emphasis is placed on that because the child is quite young, very easy to be influenced, etc., which is different to a situation like this, which may occur when the child is 14, 15, 16, where the child's views carry more weight. But at the moment, things as they are, we are looking at the court order being in place up until the age of 16. But thank you very much for that question. As always, to speak to me live on air, you can ring on the landline number, which is there at the bottom of the screen. We get numerous immigration law questions, and the first question we got today regarding spouse applications, I did rush through it a bit. In terms of, if I just go back to that and really focus on finances, where you are sponsoring your partner from abroad to come to the United Kingdom, as I said in answer to that question, really the issue in terms of spouse applications does actually come down to finances. And it's how do you meet the financial requirement. Now, the simplest case is where somebody is employed. And as I said, where somebody has been employed for 6 months, the easiest scenario is that you submit an employment letter, 6 months of wage slips and 6 months of bank statements to demonstrate that income of £18,600 per annum. Now, there are obviously different scenarios as well, which have to be taken into account. Somebody might be in employment for a while, but they may be in multiple jobs. So they might do a job for a couple of months, leave and do something else. They might be on fixed term contracts. They might be on 0 hours contracts. And it may well be that multiple types of different jobs undertaken over different time periods are the source of the income of the sponsor in the UK. Different rules apply to that. It may be that instead of employment income, somebody is self-employed. They could have a shop, they could have a factory or something that they're operating, and their income is through profits. They may be self-employed as a sole trader or a partner. They may be self-employed as a director of a limited company. And there are different rules which govern that scenario. Another common type of scenario that you come across in practice is where people receive rental income. And again, there are specific rules about rental income as well, in terms of how you demonstrate rental income, what you can combine it with. Another common scenario that you come across when you're making spouse applications is where somebody is relying on savings. So they may not have a job at all, or they may have a job which doesn't pay as well, but in addition to their employment income, they've got savings as well, and it's the savings which is going to add to the employment income. So there are various different ways in which the financial requirement can be met. And Brother Muhammad Zaifa, who sent the question in, obviously sent a general question in about sponsoring the spouse from abroad, and I've tried to cover as many different circumstances as possible. And I then came on to deal with accommodation. And I very quickly said accommodation is not normally an issue. It isn't. The accommodation isn't one that you have to own yourself. It doesn't have to be accommodation for which you personally have a tenancy agreement. You could be living with family, you could be living with friends, and there are ways in which you can demonstrate that that accommodation is available to you and your partner who's coming to the UK from abroad. It could be that all that's required is a letter from the owner, a letter from the lead tenant, that or the main tenant, that you can reside at the property with your partner. So it doesn't have to be property you own. It doesn't have to be a property where the tenancy agreement is in your name. So accommodation has to be available. It's got to be sufficient. So you may need to produce a housing report just to explain how many rooms there are, who lives at the property, is there enough space for your partner or not to stay with you at that property. So on the accommodation front, there will be some evidence of who owns the property, what permission you've got, whether as an owner, whether as a tenant, or whether a letter from the owner or tenant. So what basis is it upon which you are occupying the property, and is there sufficient accommodation available for you and your partner? Again, that would normally be demonstrated by way of a housing report. So that's how the accommodation aspect of the spouse visa rules are dealt with. Now, just very quickly, at the end, you do need to demonstrate that your relationship is genuine. How do you demonstrate that? In most cases, all that is required is for you to show that, we got married and here are the photographs. Looks genuine. A number of people attended. And then after the marriage, look, here are photographs of us together. So you could be out and about, restaurant, parks, or just at home with selfies, etc. So it's photographs that the Home Office normally looks at to assess whether the relationship is genuine or not. Generally speaking, there are exceptions. You wouldn't normally need to submit evidence of calls, messages, money transfer receipts, or anything of that nature anymore. The Home Office stopped asking for that approximately 2 years ago. So no real need, unless requested, to submit evidence of calls, messages, money transfer, receipts, etc. So the assessment really is made on photographs, wedding photographs, and other photographs together. And other photographs together are really simple. They are basically normally just selfies of yourself and your partner who is abroad. So that's a quick run through how a spouse application is made. We're taking a short break. We'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, please do continue to send your questions in on the mobile number, which is also there at the bottom of the screen. So landline number to speak to me live on air. Please do continue to ring us with your queries. And please do continue to send your questions in on that mobile number as well. Now, let's go to the next question that's come in. And this question relates to indefinite leave to remain application. And the question is as follows. I have been living in the United Kingdom for 10 years. my residence in the UK has been legal, but it has been made up of different types of leave. I initially came to the UK on a student visa, and I then switched to a spouse visa. I've now been in the UK for 10 years. Can I apply for indefinite leave to remain? Common question. And I think the reason that this question comes up is, for example, when someone is granted a particular visa under a specific route, for example, a spouse visa, a partner visa within the United Kingdom, you're normally then issued with a letter when that visa is granted. And that letter says you've been granted a visa under this route, and to qualify for indefinite leave to remain, you would need to complete, let's say, 120 months, or it could say you need to complete 60 months. So they look at that particular route, they look at what the letter says in relation to when you can apply for indefinite leave to remain. And they think, well, you have to, now that I've moved into this particular route, whether it's the partner route, whether it's the 10-year route, the letter says I've got to do 60 months, or it says I've got to do 120 months. So I've got to complete that before I can get indefinite leave to remain. Now, that's partially correct. If you stayed in that route and you wanted to apply for indefinite leave to remain in that particular route, whether it's the partner route, whether it's the 10-year route, whether it's on a work permit, the skilled worker visa, if you want to get indefinite leave to remain under that specific route, then yes, you complete the time period necessary under that particular route. But that doesn't mean that you're prevented from applying for indefinite leave to remain under the long residence rule. The long residence rule applies irrespective of your current visa category, current visa status. And the long residence rule, where you can apply for indefinite leave to remain, is basically for somebody who has lived in the UK legally without any unlawful periods. Now, there may be some short gaps where you can get away with unlawful residence. There are specific rules relating to that. There are rules about when you might have gone abroad and got a visa and then come back again. Where there's a short gap, you can still consider the whole period as being one of lawful residence. But the point is that the 10-year legal residence route, whereby you can qualify for indefinite leave to remain, applies to anybody irrespective of their current visa status. And the beauty of that rule is that you can go back and combine all the different types of visas that you've held to qualify under the 10-year lawful legal residence rule. So fair enough, your letter might say complete 5 years, complete 10 years, but you can still rely on the 10-year route, irrespective of what that letter says. And I think it's the letter that people get with their initial visa. It's the partner, whatever, which confuses people. But look, the 10-year route is there. But thank you very much indeed for that very interesting question. Let's go to our next caller. Hello, assalamu alaikum.
Welcome, Salam. Can you hear me?
Yeah, I can hear you loud and clear.
Okay. Okay. Basically, my question was in regards to a visa. So
Okay.
basically calling someone over from Pakistan.
I understand.
I just needed to know, like, what is the process, what documents are needed, or if there was any website that I could use for reference purposes.
Okay. The problem is, I'll be honest with you, there isn't an easy website that you can go on which explains what you need to do. But what I say to clients is break it down in terms of what you need to do and what they need to do. So what you need to do, you're going to be the sponsor. So you're demonstrating that you're able to look after them financially and you can accommodate them. Okay? So that's your job as the sponsor. So you would do a letter or get a sponsorship declaration through a solicitor. Basically say, look, this is who I am. This is where I work. This is how much I earn. These are my savings. This is the accommodation I've got available for my relative who I am inviting to come to the United Kingdom. And your supporting documents would be passport copy, yours and if you're married, your husband's, 3 months wage slips, 3 months bank statements, and proof of accommodation. So that's what you would do as the sponsor in the United Kingdom. typically you need savings of about, I would say, £2,500 for one person. If two people are coming, around £3,500 should be enough. So that's what you do as a sponsor from here. Now, in terms of what they need to do, what I tend to advise clients is, look, if they can use an agent or a lawyer in Pakistan to do the application, let them do it there. It's cheaper, it's easier, as long as the person is reliable. They will then submit their own documents about income and finances, not to show that they can meet the expenses of the trip, but to show that they live in reasonably okay circumstances, so they will go back. So they will submit evidence of their ownership of property, ownership of assets, bank statements, income, family, etc. So it's a bit confusing if you try and do it all together, but my personal view is, if you can limit it to you doing the sponsorship here and them doing the online form and their supporting documents through an agent or lawyer in Pakistan. Does that make sense, or have I confused you completely?
Okay, so what you're saying is basically, in order to sponsor them, I do the sponsorship from here, whatever, like the points that you made.
Yeah.
And then you said there's an online form. So what is this online form? Do I just find it on the gov.uk website?
Yeah, it is. So if you really want to do it yourself, actually, you can find the form on the government website. So even if you Google standard visitor application UKVI or visitor application UKVI, that will bring up the visitor page, and basically just follow it through, and you answer the questions not from your perspective but from the visitor's perspective. So in terms of where you are, what your name is, they're doing the application. So if you really wanted to do it, absolutely fine, you could do the visitor form yourself from here. So
if I'm doing it for two people, do I need to fill in two separate applications?
Two separate applications. But you know, when you do the form, they'll ask you, are you traveling with somebody else? So you mention there that, yes, I'm traveling with, for example, my husband. And the husband will mention in his form that I'm traveling with my wife. So they know they are connected applications. So when they're processed together. So
Okay. And if while doing this or anything, is there any way that I can contact you just so I know that I'm following the right process and so forth?
You can do. If you take my number after the call from the control room, sometimes it's easier if you just send me an email and I can just guide you along in terms of what needs to be.
That's
so
perfect.
break it down into three things: your sponsorship, online form, and then their documents to show they live in okay circumstances. Basically, do they live in comfortable circumstances or not? That's really what you're looking at. Sponsorship, online form, their documents to show that they live in reasonably okay circumstances. That's how it's broken down mainly.
Okay, so when you say sponsorship, so obviously that's myself, does that information go onto the form? So the first step is basically filling out the form?
Yeah, you could put it on the form. So they ask you in the form, who's the sponsor? How much are they willing to sponsor you for? And I normally say £2,500. They will bear the cost of all the expenses. There's a little box that you fill in because they are inviting us to come to the United Kingdom. So but that's quite brief. In the online form, the sponsor's information is quite brief. It's the actual sponsorship declaration, which then includes with it passport copies, 3 months wage slips, 3 months bank statements, proof of accommodation. That goes with the sponsorship declaration, which is a standalone document that you prepare. Okay,
that's fine. I'll still take your number after the call and hopefully just start it through.
Okay, no problem. You take my number and then I've got no problem giving you some further advice or guidance in relation to that.
Thank you.
No problem. Okay, thank you very much, Jazakallah, for your call. Thank you very much. So, it is a season for sponsoring visitors to come to the United Kingdom, or so it seems at work as well, to be quite honest. I think what's happened is we've had the pandemic, people weren't able to travel for good 1.5 years or so. So now you find that a lot of people are making visitor applications to come to the United Kingdom. So a lot of queries from clients who want to sponsor relatives from abroad. Now, you don't have to do it this way, but what I tend to advise clients is, look, you sort your documents out here in terms of your ability to sponsor somebody. And when we say sponsor, what we're really saying is that you're able to look after them financially, you're able to accommodate them in the United Kingdom. So get that together here. Normally, if you've got a reasonable income, it doesn't have to be particularly high, but reasonable income, and you've got savings of about £2,500, that's normally more than enough from your end. Online form, I normally say to clients, look, why don't you just get the lawyer or agent in your home country or the visitor's home country to complete it. But if you want to do it yourself, or if you want to get a lawyer to do it here, absolutely fine, they'll do it. But I think the key aspect of the application isn't so much the sponsorship or the online form. I think the key aspect of the application, which is difficult to get right, is the applicant, the actual visitor. You're looking at their circumstances. How do you demonstrate that the visitor will go back to his or her own country? Have they got assets? Have they got close family? Have they got a good income? Have they got savings? Why will they go back? What are their ties to their home country? Really, that's the key aspect. And I think you do need to spend a bit of time on that, gathering evidence, pulling it all together and explaining the visitor's circumstances in their home country, explaining that to the Home Office. I think that's the key to a successful visitor application. But thank you very much for all your calls today and all the interesting questions on WhatsApp. Inshallah, we'll be back next week. See you then. Assalamu alaikum.